Welcome back. I'm Pamela D Wilson, caregiving expert, advocate, and speaker. We're here to continue to talk about memory loss planning. And in this part, we are going to talk about legal planning, which is another one of my favorite subjects. As many of you know, I was a court-appointed guardian, a medical and financial power of attorney, personal rep, trustee, and a care manager for many of my clients. So I am very well versed in the importance of legal planning. I actually have an entire separate course on power of attorney. But as always, let's get started. I'll take myself off video. We'll go through the normal housekeeping tasks, and then we'll get rolling. Bear with me for a moment while I change the slide. So housekeeping, you know this. Use the term elderly parent or elderly spouse. I talk about this all the time. Substitute it for whoever you are taking care of. The outline for this module is in the course materials. If you haven't printed out the slide handouts, stop the slide, print out the handouts, come back. The ellipses, the ... on the slides, I purposely put them there so that you follow along with me and can learn. So let's talk about the objectives of what we want to achieve from this section called legal planning. At the end of the legal planning section, you should be able to move ahead to talk to elderly parents about the importance of estate planning and demonstrate the importance of being prepared for unexpected health concerns, which is the benefit of all of this legal planning. Doesn't matter if you're 21 or if you're 81, you should have documents. So why do we need an estate plan? An estate plan is like an insurance policy for life that relates to healthcare and money management. How many of you out there have completed your estate plan? If you are ahead of about 80 to 85% of people who have not, either because they don't understand what an estate plan is, or they don't even know that estate planning exists, because unless you have had health issues many times, it's not discussed. So the insurance policy of an estate plan. You insure your car, your home, you have health insurance. All that time, you hope that you never have to use any of those plans. An estate plan is similar in that you're not going to use it today, but we will all use an estate plan because of, what do you think? The reality of life and death. None of us are going to get out of here alive, as uncomfortable as that thought may be, as sad as that thought may be. We all think we're going to live forever, be healthy forever. It doesn't work out that way. An estate plan is made up of these documents: medical power of attorney, financial power of attorney, a living will, and a will or a trust. So let's talk about power of attorney. Powers of attorney are documents and a named person called an agent. The documents are used to appoint a person or persons to act for us in the event that we become sick or disabled. In these events, we may be able to act for ourselves because of a physical disability, maybe a severe car accident, or we may have mental difficulties like Alzheimer's or dementia that make it difficult for us to evaluate information and make decisions. We could also have general health issues not even related to Alzheimer's or dementia, and can benefit from the assistance of a power of attorney. In my life as a professional fiduciary, that's what people are called who serve as power of attorney and guardian and trustee for people, many of my clients were in the planning stages. They were not yet at the point where they needed help or had health issues, but they wanted to make sure there was an emergency plan in place when and if something happened. And they wanted to make sure that someone knew where all of their documents were, their health diagnosis, everything that was going on. Let's specifically talk about medical power of attorney. A person in the role of medical power of attorney assists with medical decisions, medical care, everything related to health and well-being, and where the person lives. As a professional fiduciary, I served as medical power of attorney for elderly parents who didn't have children, elderly parents who didn't trust their children, or who did not want competition among their children. They didn't want to appoint one person and then have the other children ask, well, why didn't you appoint me? Didn't you trust me? Know that anyone, can appoint professionals like myself to serve in any legal role that you choose. The person that you or an elderly parent appoints to be the medical power of attorney must be someone that you fully trust to make decisions about your health. And fully trust can be a family member. It can be a professional who has the experience, who's been doing this for a number of years. The decisions about your health include where you live, the treatments you receive, end-of-life care, everything related to health and well-being. It is very helpful, but not necessary, for the person to have medical background. Many family members don't have medical background. They struggle, but they also can access professionals like myself and care managers and other people who can help when things get medically complicated. Whoever you appoint, that person should have very deep knowledge about your health conditions, the medications you take, past surgeries, allergies, your wishes about medical care and treatment, or they have to be willing to learn, because at the time decisions have to be made and you cannot speak up for yourself, that person has to know with certainty what you would have wanted. They have to learn to become an advocate. Advocacy is a very important component of being a medical power of attorney. So I want to talk about for a minute another client story. And this one I call the 4th of July phone call. So 4th of July, a few years ago, I was out and about. I was hiking. My cell phone rang. I received a call from a hospital here in the Denver area saying, we have Karen here. We see that you are the medical power of attorney. Karen is on a ventilator. She is on life support. She cannot speak for herself. We need you to show up with your documents, and we need you to tell us what Karen wants for her care. And can you answer a couple of questions for us right now? I said, yes, I can. I answered the questions because I knew Karen. Ran to my office, my computer, printed off the documents, drove to the hospital, got there within the hour, met with the nurses. When I walked in Karen's room, it was amazing. Machines were beeping. They were breathing for her. They were keeping her alive. She had bruises all over her face. What they think happened is that she had a fall in her home, and a neighbor found her, called 911. She got taken to the hospital emergency room. They were still doing testing. They didn't know if she had a stroke or what happened with her. But what I was very clear with them about was that Karen wanted treatment. Karen wanted to live. We talked about all of her health issues and allergies and just everything that had happened in Karen's health life, because it was somewhat complicated. Now, had I not had all of that information, had I not known about Karen, I would not have been an effective or an efficient advocate for her. So imagine this happens to your elderly parent and you do or don't have documents. You have to show up at that hospital. You have to show up at that emergency room and talk to people. Can you do that? Do you know the health conditions of your elderly parent? Do you know their medications? Do you know their past surgeries? Do you know their allergies? Do you know what they want? This is why estate planning and power of attorney is so important. Let's say you like to ski, you like to go boating, you drive a car. Any of those activities, accidents happen, things happen. You could be Karen in a hospital emergency room with people not knowing who to call, not knowing if you have a power of attorney or not. Do you want to be in that situation? Most of us would not. This is why planning is so very important. Let's continue. So let's talk about financial power of attorney. This is the other half of power of attorney. A person in the role of financial power of attorney assists with or makes financial decisions when you or your elderly parent cannot. If a family member, the same person, the same family member, can serve as both medical and financial power of attorney. If a professional is appointed, the same person can serve as both, or the roles can be separated. If it goes to guardianship and conservatorship and it's not a family member, the roles are normally separated. The financial power of attorney coordinates costs of care with the medical power of attorney. if it's not the same person. So as with the medical power of attorney, the person you appoint to be your financial power of attorney should be somebody that you trust with your money. It's helpful but not necessary that this person is familiar with managing money, financial investments, selling property, familiar with your financial situation. Anybody who is appointed a financial power of attorney should set up a system of oversight to prevent financial power of attorney abuse that commonly happens within families. I've seen it. Children feel entitled to their parents' money. They get on the bank account, they start taking out money, and then when the elderly parent needs care, there's no money left. Monthly reports should be given by the financial power of attorney to a designated person. It could be another family member, it could be an attorney, but just somebody to provide oversight who can ask questions about any expenditures or any transfers of funds that seem questionable. Oversight of money is a very good thing. The person who's doing the oversight should have the power to request an investigation into finances and have the power of attorney removed if there are concerns that that financial power of attorney is not acting in the best interest of the elderly parent, is not spending money for their care, is using money for personal use. That protection should be put in place, and it can be put in place in the document. Let's talk about a living will. Very, very important. A living will is a document where wishes about end of life are stated. A living will is a legal document. You may have heard of some other documents that are similar, called 5 wishes, a DNR form, do not resuscitate, a most form, or a post form. The DNR form, the most form, and the post forms are forms that you can get from your doctor. You can also find them online. 5 wishes is also online. 5 wishes is a document that might help to familiarize you with the types of wishes associated with the end-of-life care. The DNR, the most, the post, those are different. They're forms provided by the healthcare system like a hospital or your doctor to help you direct emergency care. Those forms, the DNR, most, and post, are very simple. They only ask you a few questions. The main question is, do you want to be resuscitated? They are limiting in the degree and the limit of the extent of care, which is why having a living will is important. A living will is the legal document that supplements all of those forms, where you can explain as much as you want about your wishes. Common areas of discussion are, would you want to be placed on life support? Under what conditions? How long would you want the life support to last? Do you want a feeding tube, a breathing tube? Under what circumstances would you want antibiotics or not want antibiotics? What happens if a medical error happens? These are all very important considerations that should be placed in writing and discussed with your elderly parent or people who you appoint to be your medical power of attorney and your family. Having this documentation, having these discussions, it avoids confusion about what you would want, who you would want to act for you, what your wishes are, especially when you can no longer make these decisions. We'll briefly talk about wills and trusts. A will is a document that provides instructions to your personal representative. A personal representative is the person that you appoint to act for you after you die, after your death, to dispose of your property, your bank accounts, your money. A trust is similar, but you can also have a living trust that gives permission to this person during your lifetime to do that under certain circumstances. All of these documents we talked about, they comprise an estate plan. It's never too early to have an estate plan because we never know when we might be involved in an accident and need help. The best type of attorney to help you with your estate plan is an estate planning attorney, an elder law attorney, a probate attorney. Estate planning attorneys, elder law, and probate have expertise in this area. Don't use a friend to do these documents. Don't use a family law attorney. There are intricacies about estate planning that are so important. So I want to share one more story. And this is the story of David Drummond, and I call it Eat Cookies. There's a 17-minute video on my website. If you go to the link in this slide and you scroll all the way down to the bottom of the page, you can watch the video. The video may make you smile. I can guarantee it will help you take seriously the idea of estate planning documents. May make you cry. David Drummond was a gentleman who lived here in Denver in his middle 30s. Very active, physically active bodybuilder. One day sitting on a retaining wall, falls backward, hits his head. Severely disabled from the neck down, paralyzed, on a feeding tube, on a breathing tube, never will recover from this accident. He didn't have estate planning documents. He didn't have a medical power of attorney, living will, financial power of attorney, nothing, because he was too young. He was in his 30s. Whoever thought an accident like this would happen? A freak accident, falling backwards off a retaining wall. Who would have ever thought? David told the doctors at the hospital, I don't want to live like this. I want all these machines stopped. Because David didn't have those documents, they weren't sure whether he understood what he was asking. They weren't sure whether he understood that if turning off those machines would end his life. Months go by. Doctors are involved. The hospital ethics committee is involved. They're all talking about David. They're trying to figure out whether David knows really what he wants, whether he understands the consequences of turning off that machine. Finally, David gets his wish. They agree that he understands after many neuropsychological evaluations, all of that. Before his death, David asked his doctor, Dr. Martinez, to help him make this video because he didn't want another person ever to have to go through this. You, over the years, have probably heard of many cases, Terry Schiavo, cases in the news where situations like this happened. And the person was saying, let me go. I don't want to live. I don't want to go through this. But they didn't have documents. The families were arguing, husbands and wives, children saying, oh, we don't want to let them go, keep them on the machines. It's tragic. David made this video for that purpose, so that to emphasize the importance of having these documents. So David gets his wish. He makes the video. They have a date set where the machines are going to be turned off. Now, if you know anything about people who need total care and are fed by feeding tubes and all of that, the aspiration related to dementia. So someone has dementia, they are fed, they have difficulty swallowing, they can choke. Food goes into the lungs, they get pneumonia, they aspirate, very difficult situation. Some people will have feeding tubes, so they don't eat through their mouth, they don't swallow anymore, it goes in through a feeding tube. Similar things happen, that fluid can back up into the lungs. This is what happened to David. He aspirated food, got pneumonia, and he passed away before the machines could be turned off. So he died peacefully. He died the way that he wanted to. He didn't have to live his rest of his life hooked up to machines and needing total care. So I highly encourage you, if you have any doubt about doing estate planning documents, if you think, oh, I don't need it, oh, I can put it off till later, not something I need, go to my website, go to this link on this slide, watch the video, share it with your parents, play it for your parents. I can say with almost absolute certainty that you will see the reason to do your documents after watching David Drummond and Eat Cookies. Let's proceed on to the next slide. So another one of my favorite slides, it can be too early or never be too early, but it can certainly be too late. This is, again, a follow-up from information that we talked about in a prior segment about when dementia has progressed and appointing a power of attorney is no longer possible because your elderly parent can't remember. That you run into a dead-end road. For all of us, especially for elderly parents with dementia, it's never too early to complete estate planning documents, but it can be too late. Elderly parents who are unable to understand the estate planning documents lose the opportunity. They lose the ability to create their estate plans and living wills and say and put on paper what they would have wanted. In that case, they have to rely on somebody else. The court system can become involved and appoint a guardian or a conservator in the family or a professional like myself. The guardian and the conservator are appointed. They are given the power, the absolute power to make healthcare and financial decisions. Don't be that family that leaves estate planning up to chance. Plan today. As I mentioned at the beginning of this segment, more information about appointing and acting as a power of attorney is on my online power of attorney course. That is on my website. So as we talked, estate planning, it's one of the most important things that you can do in your life. It is an insurance policy that your wishes will be carried out, assuming that you appoint the right person, assuming that you appoint a person that you fully trust. I'm Pamela D Wilson. Thanks for being here with me for the legal planning segment. I will see you in another webinar.